it would be easy for a defense lawyer to simply say, come on, judge, we all know what's going on here. There's no way this guy's getting a fair trial here. There's no way that these jurors haven't been contaminated in some way, shape, or form. This is a tragedy of the highest order, and it's been overblown, and not even overblown, but even underblown. It's still almost impossible. You would be arguing that, and that wouldn't be a horrible way to argue it. But what they did here that I like is that they went and found experts. And look, do you really need an expert to tell you that it's going to be unfair in this small county?
I don't think you need an expert, but it really helps. That's for sure.
It gives what we're doing in the real world of lawyering is what we want to give the court, the judge, what he or she needs to make the decision in our favor. And sometimes you got to get a little creative, and this is, I'm not saying this is creative because obviously that this isn't they're not the first lawyers who have done this, but they did do it. And they not only got experts, they did some sociology type studies, like how many people are in this county? How many people have heard of this? What's the percent? It did that kind of stuff.
Yeah.
So they gave concrete terms. The law the law is this really abstract thing. And when you start talking about prejudice, this is a term we throw around in our line of work all the time. Well, judges would be very prejudicial to the defense, but you can't really define that. These lawyers gave the judge a way to define this. It's like, all right, there's only X number of people in this county. Of those people, we have this many that'll be called in to be jurors. And we know if you just statistically look at this, these jurors are going to be contaminated by all the hype and publicity of this mess. Now, on the other hand, if we go to a different county in Idaho that's got more jurors, you're going to be less likely to find jurors who have heard about it, or if they've heard about it, they won't be personally impacted by it. And, I don't think anybody needed an expert to really say that or to make that argument because it's sort of understood, but they did that. And now what they have done is they created a record. Now, they didn't need the record necessarily because they won the motion, but they created a record. So if the judge would have denied this motion and made them try the case there in that small county, when the Court of Appeals looks at it, and you've done this with me now, you've seen when there's an appellate record and when there's not. When you hear objection and there's no description about what the heck is going on, it's really hard on appeal to do anything about it. But here, if the judge would have said, no, I'm not changing venue, we're doing it right here, I don't give a crap, this is where it happens. These victims are here, the families are here, I'm doing it here. And the only argument was, well, that would be really prejudicial to us, judge, and nothing else. Well, then on appeal, you're looking at it's like, yeah, we don't really have any basis to overturn this.